Welcome and welcome back to Really Legal. I'm attorney Ethan Bearman. So the jury trial for Donald Trump continues to move forward, and I'm going to discuss that bond company with Mueller, she wrote, in just a second. I'll give you the good, the bad, and what's next. So today in Judge Merchan's courtroom in New York City, Thursday, April the 18th, 2024, 2 jurors were removed. We have a full set of 12 now. We still need alternates. So it's moving forward quickly. Monday really does look to be on track for opening statements. But there was something that happened that caught my attention this morning, and that is numerous media outlets shared some of the biographical information about the jurors. This is actually how we lost one of the jurors this morning, is she was scared and didn't want to continue. And Fox News host Jesse Waters Tuesday evening, like others in the media, shared this biographical details, but in this case about juror number 2, her neighborhood, her occupation, her education, marital and family status, what industry her fiance works in. Look, this type of information can help you figure out exactly who this person is, right? It's too much info. It's actually why this morning in court, Judge Merchan said to the press in attendance, stop sharing all this biographical information. We don't want people to be able to figure out who the jurors are. That's the whole point here of not sharing their names, is we don't want them to be intimidated and feel like they can't do their job as an objective juror. But here's the thing about what Jesse Waters did. And this is what I think was wrong, and I think it's atrocious, and I think it's actually reprehensible. He didn't just share information. He shared it all together at once and concluded by saying, and I quote, "I'm not so sure about juror number 2." Because he also claimed that undercover liberal activists are trying to get on the jury, which of course Trump promoted. That is its own form of not illegal, by the way, not illegal juror tampering. Look, juror number 2 is gone. Juror number 2 withdrew. Juror number 2 had to be replaced. That's just hideous. You don't participate in situations that cause people to be doxxed, hunted, tracked down, intimidated, abused. It's not right, and nobody should be doing that. And Jesse Waters, his mom, should probably spank him. Although he might like it, I don't know. So that's just really bad. So let's get back into that bond company. So coming up in just a second here, I want to introduce her, Allison Gill. You know her as Mueller, she wrote. She's host of the Daily Beans podcast and the Jack podcast with former Deputy Director of the FBI, Andrew McCabe. But Allison Gill has been doing investigating into Mr. Hankey's bond company. So Allison, first off, I just have to say, I'm so glad you're taking time out of your day to join me. So thanks for coming on.
So thank you.
So I have talked about, my big bombshell the other day was the fact that this bond company undermined their own client in the AG Letitia James case in New York, which I find to be just mind-boggling. And there are so many questions circling around about this Mr. Hankey, which, yes, the Christmas boo. Yep, exactly. But you've been doing research into them. I'm just really curious to hear what have you uncovered? Tell me about this.
Well, as we know, when they filed their paperwork for the bond, they left off their financial statements. And I'm talking about Knight Specialty Insurance Company. They are domiciled in Delaware, and they go by KSIC. So we'll talk about them quite a bit. And they've left off their financial statements. So the court rejected it. And at first I was like, oh, probably an administrative error. No, they probably didn't want the New York Attorney General or the court to see their financial statements, because when they refiled with their financial statement, you noticed that they only have $138 million in cash, which does not cover the $175 million bond. So the New York Attorney General objected to the bond, a surety from KSIC. And for a couple of reasons. From an exception in the law, they're not actually certified insurers in the state of New York. And so now they're having a hearing was set for April 22nd, which is a day before the gag order hearing, April 23rd, in the election interference trial, which is a few days before the immunity oral arguments before the Supreme Court. So it's a pretty packed week, that week, the week of Passover.
It's weird how, when you do things that appear to be crimes, that suddenly you're spending a lot of time in court. I want to talk about something for just a second, though, before we move forward. And that's when I was looking at this as an attorney in California, it looks like New York rules are very, very similar. And I think a really important point in all of this that I like to emphasize, especially in light of the E. Jean Carroll bond that we can talk about briefly as well, but Chubb, who underwrote that bond and issued that bond, is a registered company in the state of New York. So they don't have to give a financial statement every time they issue a bond. In California, it's the same way. If you're registered here and an authorized bond company, you're not issuing a financial statement every time a bond is issued. But because KSIC, is that our acronym that we're using? Because they're not registered in New York, now they get all this additional scrutiny because they're not filing once a year and submitting all that paperwork at once. Right. I think that's really interesting that this is, Trump couldn't get, what did he say, 20 other bond companies, 30?
30. And there's something important about that too. Days before the appeals court in New York, and I can't keep it straight in New York. There's no superior court. The regular court's called the Supreme Court, and then there's an appellate court above the Supreme Court, I think. But right. Trump said, and his lawyers were like, we asked 30 different companies. Nobody is going to back this bond. We need to lower the bond. Days before the appellate court decided to lower the bond to $175 million, KSIC and Trump were in negotiations to cover the full amount of his bond, and they did not notify the court. That could be a problem, and we'll hear about that, I'm sure, at the hearing as well on April 22nd. But what happens is now KSIC had to file their brief for this hearing and say why they can, are able to be the guarantor, I guess, of this bond. And their reasonings were very circular. They said, no, we're not certified, but we are certified to write excess line policies in New York, which you can be if you maintain like $48 million worth of stuff for clients and, you are out of state. And they're in Delaware. But that's for excess line insurance, which is like, insuring odd or high risk things, like polymolecular hair or.
And I've seen that. So even outside of the court system, in just general business transactions, you'll have tranches. The bigger the company, the more complex the transaction. They have what are called tranches of these types of policies. And so access, that exists in normal circles, but it's not a normal thing in a bond to keep the attorney general at bay from seizing your property while you're appealing a roughly $450 million judgment against the Trump organization and others, of course, in New York. Everything about this is weird.
Yeah. And so they justify their ability to cover the bond by saying, first of all, we can write excess line policies in New York. We're eligible to do that through a group called ELANI, which is the Excess Line Association of New York. And I went on to the ELANI website, and they have lists of people who have gone through ELANI's strict scrutiny, and KSIC showed up nowhere. So I wrote them an email, and I said, does that mean that they aren't eligible? Because they got a letter, which they submitted with their paperwork in 2021 saying they were eligible. And they explained to me that not all eligible excess line insurers are listed on our website. Only the ones who volunteered to go through our vetting process are. So an insurer can be eligible to write excess line policies in New York and not be listed on our website. I was like, all right. So they say, KSIC says, so we're able to secure this bond even though we only have $138 million because Donald Trump has collateralized this bond with a Schwab account worth pretty much exactly $175 million, $175.3 million. And my first thought was, how can you guarantee a bond over somebody with their own stuff? Like, it didn't make it. I understand collateralizing the bond to get that bond done, but the bond person issuing the bond should have to be able to cover it. And so the way that they get around that is they say, well, we have this great parent company called Knight Insurance Company, KIC, not KSIC, but KIC. And they have like $1 billion in, they didn't say cash, they said cash and equities. So it could be like $9 in cash and almost $1 billion in real estate equity, or, something that they didn't really explain if it's quickly accessible cash, right? Because that's why a lot of you can't back this stuff with with real estate, is because you have to put it on the market and sell it, and it takes a long time. Right. And they said, so with Donald Trump's $175 million Schwab account and a reinsurance agreement with our parent company, so their parent company is insuring them to insure Trump, with $1 billion in assets and equity, we can totally do it. Now, back to the $175 million Schwab account. Chubb used as collateral to back the E. Jean Carroll bond a Schwab account. So is this a different, totally new Schwab account, or is it the old leveraged Schwab? Does it already have $91 million in leverage against it in the Chubb group thing? So I don't know that. We don't know that because the paperwork they submitted for the $175 million Schwab account, it might as well be a hurricane map with Sharpie written on it. It just says, we have a Schwab account of $175 million. That's all it said.
And what's so unusual to me, based on my experience with this as well, is when there is a cash amount that is going to be due, that this bond is insuring, right? That it's really not heavily disputed at this point. He has a judgment against him, or the court ruled against him. Let me say that, and it's being appealed. But the ruling is $450 million. The bond, the undertaking was ordered reduced to $175 million. In my experience, if you have a $175 million undertaking that could be cashed in as soon as the appeals court turns you down, for example, the underwriter, the bond company, wants $175 million in cash, or a cash equivalent called an irrevocable line of credit, which is essentially a loan from your bank. But they want that money not in a third-party account. I've never heard of that, where they want it in a third-party account, or that's acceptable. That's really bizarre to me.
Yeah, and they said in their paperwork, in the filing to the court, that they have control over this Trump Schwab account, and they can exercise control over it within 2 days. After 2 days, I think they have to wait 2 days. But like, if you're taking the cash from the guy who you're guaranteeing to guarantee the bond, it just doesn't make, it's so circular. It just doesn't make any sense. And then you have to have a reinsurance agreement with your parent company who's not certified at all. And then, so I think what they're going to be looking at on April 22nd is whether or not somebody who can write excess line policies in New York, because you have to have a New York broker to do that, right, whether or not that counts as being certified, because the New York Attorney General is arguing that they are not certified, insurers in the state of New York, whether that qualifies, because KSIC is arguing that it does, and then whether or not the $1 billion that their parent company has is actually an accessible fast cash, and whether or not a insurance New York insurer can have a reinsurance agreement, and whether or not this $175 million bond Schwab thing isn't already leveraged. Is it a totally free and clear account? Has it already been used to secure the bond in the E. Jean Carroll case with the Chubb situation? And what was interesting too, and Southpaw pulled this out on Twitter, the signature page is actually the signature page for the Chubb Group E. Jean Carroll bond. So either they copied and pasted it, or they were using the E. Jean Carroll bond filing as a template and forgot to put their correct signature page on it.
That's hilarious. A simple error, possibly. Here's a thought, Allison, that occurred to me. So if the judge disallows this bond for the undertaking, if the judge is like, nope, this is no good. If I'm AG Letitia James, the second I have that ruling in hand, I'm going to immediately put a lien, send the sheriff to go get that $175 million out of that Schwab account. So I'm going to collect that instantly if the bond is denied, because now I know where it is. They don't even have to hunt that down.
Yeah, no, it's like, here's $175 million I have, maybe, if you're lucky.
If it's really there, right?
Yeah, and I'm also wondering, too, if they reject the bond and say, I'm sorry, Mr. Hankey, the Christmas poo, you may not be the suretor of this bond. I imagine the court will probably give him an additional period of time to secure a bond, but I think they'll also want to look into why he didn't report to the court when they were considering lowering the bond that he was in negotiation to cover the bond. And that is something I think that Barbara Jones, the fiscal monitor who has been appointed, and the New York Attorney General has actually asked to expand again her role by allowing ex parte discussions with her about reaching out and trying to secure bonds. So I think they might resolve that during the hearing. And I think you may see an additional, maybe 10 days or something, a small amount of time. I don't know. Seriously, none of us have ever been in a situation following anything like this.
No. I mean, like everything with Trump, this is just it's unprecedented. It's an unprecedented alleged attack on our election that he's going to probably, depending on what the Supreme Court says, face justice on. But what he did in New York, while certain people are trying to claim that that's business as usual, which is absolute garbage to me. I know so many honest businesses who do not have one set of books for the tax man and one set of books for although actually convicted in this case, according to Judge Engeron, right? So he's already been convicted of this. And separately for the banks and the insurance companies, everything about this is just unprecedented, and then to the jury today and everything else. I mean, Allison, so the bond hearing is April 23rd or the 22nd?
22nd. 23rd is the election interference gag order, which now he has violated 10 times. Right. And they brought that up today at trial. But have you ever worked on a case where a bond was rejected and they got a little extra time to secure another one?
I mean, that can happen. You can appeal back to the judge and say, hey, look, I tried really hard. I need a few more days. But at that point, depending on the judge may say, no, you had your chance. And by the way, you should have been looking for another one while this was going on. It really depends on the judge.
Yeah, and you didn't inform the appeals court that you were in negotiations to cover the $464 million bond before they lowered
to 175, right? I mean, so, it's hard to say, but I would suggest that more judges than not would not give more time at the end of that, especially because AG Letitia James is not going to stipulate to it, right? So she's going to fight it. Whereas if the opposing counsel stipulates and says, sure, we'll give him another week. I mean, that's just not an issue. Judges will say, yeah, I'll give you another week then. But here, the AG wants to start taking assets. So I can't imagine. Why would the judge now give him more time? I would struggle with that. I would very strongly argue against it. By the way, this whole time while they're trying to sort out the bond, he should be having conversations with another bond company. So yeah, if I'm the judge, I'm like, no, you've had your time. This was in question. You should have been seeking out an additional bond in the meantime. No way. I would rule against him having more time.
So would I, but I feel like he gets a lot of chances.
But it's funny though, because I know a lot of people are commenting, Allison, that he seems to get a lot of chances. And my experience in court, especially recently, is judges give people a lot of chances in court. And so they're not in the business of saying, look, you get one shot. It's just the opposite. Judges generally don't see that as justice, to say you got one chance and then we're cutting you off. That's just not how it works. Now, do I think that sometimes judges go too far in giving too many chances? Yes, of course I do. Unless it's my client, of course. But otherwise, no, really, it's like, judges are not harsh, vicious people that I encounter, at least. As a matter of fact, I think we're very lucky in California that most of our judges are really quite fair and sometimes too fair.
Yeah, and they want to give due process, so they don't want to have reasons for appeal, and they certainly don't want to have their judgments or orders thrown out or vacated, unless they're Eileen Cannon. That's a whole different story.
I mean, so is the 11th Circuit, no, I don't, let's not go down that path. We'll save that for another conversation, or for the Jack podcast that you do with Andrew McCabe. So Allison, look, I want to thank you so much for your time coming on the show today. And I hope we'll get a chance to talk on April 23rd.
I think we will. Thanks.
I hope you enjoyed that conversation with Dr. Allison Gill. Give me your comments below and let me know what you think of that type of format for this, really legal as well. So look, the good, the bad, and what's next. The good is we have 12 jurors. And so it really does look like on Monday, Judge Mershon, we're going to get opening statements from prosecution at a minimum, if not both sides, and getting this trial underway against Donald Trump, first criminal trial here that's actually happening in New York. The bad is we still need up to 6 alternate jurors. 1 got picked today as well, but we still need to get 5 more. I'm really, really worried about continuing juror intimidation that may be happening, because certain outlets might still be releasing biographical, demographic data about the jurors, and that is deeply, deeply concerning. And I would hate to have anybody else drop out because of this, but this is why we're going to need apparently up to 6 alternate jurors, which is definitely a higher number than normal. And what's next? Well, tomorrow on Friday, April the 19th, 2024, we're going to see if we can get the rest of the alternate jurors selected. The defense has only 1 more peremptory challenge. The DA has 3. I think we should be able to find the rest of the alternates. And look, I look forward to talking to you tomorrow about it as well. Please make sure to click that like button, smash the subscribe button, share this with your friends, your family, your frenemies. I always enjoy talking to you. And give me your comments below. You know how much I enjoy those as well. This is Really Legal on the Really American Network. I'm attorney Ethan Bearman. I'll talk to you next time.